Personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening at 5 o'clock, and that means we are here live in the Tan Talk radio studio to present another hour of FLALAW on the radio. This is a live legal call-in talk show. We're here to share our understanding of the law and answer your questions or address your comments regarding the law. So we welcome you to give us a call with any questions and comments that you have. As you know, our faithful listeners would know that this radio show is presented by the law firm of Perenich, Caulfield, Avril Noyes. I am Matthew Noyes, the host of tonight's show, and I can answer any questions that you have regarding personal injury, workers' comp, Social Security, disability, or really any other areas. But I also have a very special guest who's taken time out of his busy day to be available to answer questions and to share his knowledge in the probate matter and also business transaction matters as well. It's Adam Rauman. Adam, we thank you for coming again today. Why don't you introduce yourself to our listeners?
Well, I appreciate the opportunity to be here. My name is Adam Rauman. I own Preservation Law Firm.
And where's your law firm located at?
1920 East Bay Drive in Largo.
Yeah, and Adam is a Stetson grad as well, just like me. I appreciate that. But also an FSU grad.
Yes.
I'm a USF Bulls, but we won't hold that against you. But before Adam became an attorney, he spent his first career, I would say, as a financial planner.
15 years.
15 years. My dad was a financial planner, and so I can appreciate the challenges of being a financial planner. Why don't you tell our listeners why you shifted from a financial planner into what you do now?
Well, financial planning and estate planning really fit in together. The financial planning, obviously, you're planning for retirement and so forth, but then those individuals were dying. They didn't necessarily have the right documents in place. A lot of their money was getting lost to probate. So I decided to go into law so I could do the estate planning portion of it. And the name of the firm is Preservation Law Firm because that's what I try to do. I try to preserve your assets while you're alive and transfer as many of those preserved assets as we can after death without going through probate at all.
And that would be very frustrating if I was a financial planner. You spend all that time and they spend all that money trying to make sure that the client was protected. And then when he died or she died, it all went into other ways that was not beneficial to that person or his estate.
Exactly.
Right? Yeah. All right. So Adam is here to talk about probate. There are 3 ways that you can talk to us. You can call us. You can call us live here on the radio at 727-441-3000. It's one way. Second way is you can jump on our live Facebook feed at Perenich, Caulfield, Avril Noyes Injury Lawyers. That's live. We're right now live on Facebook. You can watch us in the studio, and you can also type in your questions right there, and we'll be happy to tackle those questions. If you don't want your voice on the radio, that's perfectly fine. But there's yet a third way you can get in touch with us, and that you can jump on our YouTube channel. We are live on our YouTube channel as well. And that's, again, Perenich, Caulfield, Avril Noyes Injury Lawyers. Ed's on the other side of the glass. He's checking that out. So if you have a question, you can just jump on the YouTube channel and type in your question there. And we'll be able to address your question or your concern regarding probate, personal injury, or really any other kind of matters. You know, the joy of law school is that we get to get a little bit of everything. And so I think between Adam and I, we can at least give you a little information or at least guide you in the right way if it's outside of one of our areas of law.
We know enough to be dangerous.
That's right. Oh, just enough to be dangerous. You know, but Adam, let's get started. Many people think that probate is something that's only for the wealthy. Why don't you, in simple terms, what is probate and why should the average Floridian really be concerned about it?
So probate is just the legal process of transferring title on a deceased person's assets to a living person. And anybody and everybody that owns assets in the state of Florida has to go through probate unless they have a trust and the beneficiary designation on their assets ends up going into the trust, or they put beneficiary designations directly on the assets to go directly to kids or charities or so forth, or they own accounts joint. So if you own assets with your spouse and your spouse passes away and all of the assets are joint, you won't have a probate. But when you pass away, the surviving spouse, those assets will end up going through probate. And probate gets relatively expensive in the state of Florida.
Yeah, and I have heard people say, well, I have a will, so I'll avoid probate. That's really just the opposite, correct?
Every will has to go through probate. Any of the assets that you own in your personal name when you pass away have to go through probate.
Great. And I was going to talk about it later in the show, but I think this is probably a good part to talk about because people are saying, well, I want to avoid probate. Why would people want to avoid probate? And then how would they avoid probate?
So probate can be a lengthy experience to go through. If you have, there's three types of probates. There is a disposition without administration for people who have less than $6,000. So mom dies, all she has left is a couple $1,000s in a bank account. It's still going to cost you $250 for the clerk to give you what you need to get those assets. Then there's summary administration, which is a short-term administration. If you have less than $75,000 in assets, no creditors, and that process takes anywhere between 30 to 90 days, depending on how long the courts are backed up. And that process can run anywhere between a few $1,000s, like $2,000, $3,000 to $5,000 or $6,000 to get that done.
Okay.
And then the probate that everybody's familiar with is the formal administration, which takes 12 months on average. And it's 3% according to statute, which is a guideline, and all the attorneys typically follow those guidelines. It's 3% of the first $1 million. It comes down a little bit to 2.5% of the next $2 to $3 million, and then comes down a little bit after that. So on $1 million probate, it could cost you $30,000 in probate fees in order to transfer those assets.
And that's just the attorney's fees.
That's just the attorney's fees. The personal representative gets the same type of fee.
Okay. And how can they avoid that?
So that you can avoid it by owning assets joint with somebody. So if you and I had an account together and one of the two of us passed away, the survivor is going to get the asset, and that won't have probate. But when that survivor passes, you could potentially have probate. You can put a beneficiary designation on your asset. So I could list an account to go to my wife or my daughter. However, if my wife or daughter isn't there, then I still end up in probate.
Okay. Is that a payable on death account?
You get a pay on death or a transfer on death, or if it's a retirement account, they actually have a beneficiary designation.
Okay.
And the third way to do it is to have a trust and just make sure you have a beneficiary designation to the trust, because the trust will survive you regardless of anything else.
And what about real property? What about a house or a second piece of property? Is there any way to avoid that real property from going through probate?
So on your personal homestead, we can do what's called a ladybird deed, which is a fancy term for a beneficiary designation on a house. You're going to give your house to yourself for your life, and upon your death, it will automatically transfer into your trust, and we can avoid that. Or we could transfer it directly to beneficiaries. But again, there's always that possibility of probate where beneficiaries aren't there. If it is a rental property, then I recommend you have that rental property in an LLC, and I can put a beneficiary designation on the LLC so that the LLC goes to your trust upon death.
So LLC just means a corporation?
A limited liability company.
Okay. And the benefit of that is that can avoid probate because it's a corporation, and corporations don't necessarily die.
Well, the corporations don't die, but the ownership interest has to be transferred. So we can still put a beneficiary designation on your ownership interest in that company. If we don't have a beneficiary designation on the ownership interest, then yes, the company is going through probate to transfer whatever part of that company you own.
So they still would have to go through the probate.
Still have to go through probate.
That way. All right. Well, let's be honest. It sounds like you're just a referee for an episode of Succession, but without the castle. Is that right?
In many cases, yes.
Yeah. What is the biggest misconception when it comes to a will or the probate process in Florida?
So one of the misconceptions is that I have a trust, it's not going to go through probate, which if you don't designate assets to go to your trust isn't going to work. we're going to have to use your will to transfer those assets through probate over to your trust to be transferred. Another misconception is that a trust has asset protection. So I'm going to get sued. I'm going to put my assets in a trust so I don't have to worry about losing my assets. A trust has zero asset protection
while you're living, right?
While you're living and when you pass away,
Okay.
your trust is there to pay your debts when you pass away. So even if you do have your assets go into your trust, if you owe people money, then your debts still have to be paid out of that trust before the rest of the assets can be transferred.
Okay, that's interesting, because I do hear people saying, okay, I'm going to hide, quote unquote, hide my money in a trust.
Yeah, there's no hiding from the debts that you owe people.
Okay.
There are ways to protect some of those assets. There are creditor protected assets that everybody can own. Your homestead is one of them.
Okay.
Your homestead is protected from any and all creditors except for a mechanic's lien, somebody who works in your property you decide not to pay. Property taxes or federal taxes. DeSantis is working on the property taxes. We'll see what happens on that. But at the moment, property taxes, if you don't pay them, you could potentially lose your house. And then the mortgage company, because you borrowed their money to buy the property.
Okay.
All other debts and judgments can't touch the house. Your life insurance, your annuities, and your retirement accounts are also creditor protected assets.
All right. That sounds a good way to protect your assets, to preserve your legacy the best that you can, right?
Preserve your legacy, yes.
We mentioned the word trust, and you and I know what a trust is, but our listeners may be listening and say, I heard will versus trust versus will. Can you explain to our listeners, Reader's Digest version
Sure.
of what a trust is, and how is that different than a will?
So a will and a trust do the same thing. They transfer your assets after you die. A will is public. A trust is private. A will has to go through probate. A trust will avoid probate if you set it up properly. And a will hands over your assets immediately after you pass away, where a trust, we can put strings on it. We can put ages, maybe 25, 30, 35, 40, before all of the assets are distributed. So with a trust, you can put those strings on and prevent people from inheriting all of the money at one time. Where in a will, it's all just handed over as soon as the probate's done.
So if in a will, if you give X amount of dollars to your grandchild and she's 10, in the will, in essence, they get it. But in a trust, you can still give it to the granddaughter, but put till she turns 18 or other kind of requirements on there?
Yes, but if you end up giving a minor, anybody who's under the age of 18, $15,000 or more, you're going to end up with another problem that's called the guardianship.
Okay.
The state of Florida is going to step in and control those assets until that minor turns 18, and you don't want to go through that process at
No,
all.
you don't want to do that, because that's a yearly fee for the guardianship and such like that.
It's a yearly fee, and it's time consuming, expensive, and it's complicated to work through, because every time you want money, you have to go ask the court for the money.
So if somebody did want to leave one of their minor grandchildren or great-grandchildren money, what's the best way to do that to preserve the legacy of that?
They absolutely want to have a trust. They want to have those funds go into the trust, and in the trust, you want to designate that person, how much they get, and then those strings that you want to put on it.
Okay.
So even if we put strings on it till they're 25, it's still available for what we call HEMS, health, education, maintenance, and support. So for
Okay.
example, your grandchild needs money for school, they can ask the trustee to pay their tuition bill, and the trustee can write the bill or pay the bill directly to the school and not have to give the minor the money. Or let's say they're over 18, they're 21, they're out there working, but you still had a restriction till they were 25. They get in a car accident, they need to buy a new car. They can ask the trustee for money, and the trustee can go, great, I'll help you get a new car. And you go, great, I want a Mercedes. And the trustee goes, no, you can have a Corolla.
A little more control over that. Yes. Yes. And I understand that the trust is beneficial, especially for if you have children that may not be as financially responsible as other children may be.
So the standard provisions I use are 25% at 25, 50% at 30, and the balance at 35. I can do whatever restrictions you want, but I figure if by the time they're 35, if they don't know how to manage money, I don't know what to do for them.
Yeah, no, that makes sense. And then the difference between a will and a trust, I think, is public knowledge as well.
So when you have a will, and everybody who has a trust has a will, they have what's called a pour-over will. It says if I forgot to to put something in my trust to begin with, please put it through probate and put it in my trust. But a will is public record. So if your neighbor wants to find out what you were doing, they can go down and pull the records on your will and see where your assets were going. If it says my assets are going to the trust, that's all they know is you had a trust. They don't know who the beneficiaries in the trust are or what the distributions are.
Or the assets or anything.
Or the assets or anything else.
Well, listeners, we appreciate you listening, and we do, again, welcome you to give us a call if you have any questions regarding wills or trust or any probate matter. Adam Rauman is here. He's available to answer your questions. I'm Matthew Noyes, and I'm also here to talk about personal injury and Social Security, disability, and workers' comp, or whatever other questions you may have regarding the law. I think one thing that's also good about this show is that you may not have a question. You may just have a comment about what's going on in the law or national news. We're here. We're here to answer any questions that you have, to share our perspective of that, and we welcome that conversation. So 3 ways again, 727-441-3000, or you can jump on our Facebook Live at Perenich, Caulfield, Avril Noyes Injury Lawyers, or you can jump on our YouTube channel at Perenich, Caulfield, Avril Noyes Injury Lawyers as well. Type in your questions there, and we'll be happy to tackle those as well. If you just want to see what a radio station looks like or what Adam and I look like, jump on Facebook or YouTube, and we're here waving to you now and being available for any questions that you have. All right, and it looks like we have our first caller, and it's Lisa. Lisa, thank you for listening. And how can we help you?
So I have a question. I have the Ladybird deed in place. All of our financial banking institutions have beneficiaries assigned. I have a question about my vehicles. So would I need a trust to have the vehicles protected or given to my family in case I pass?
I think that's a great question. And, I think that's what we're talking about, preserving the legacy and the assets. So, Adam, what should Lisa do? It looks like she's taken some steps. What other steps can she do to preserve the asset, such as the vehicle?
Well, the good news is the DMV likes to practice law without a license. If you end up passing away and you have a will and a death certificate, and the will says that all my assets go to Steve, Steve can take the will and the death certificate down to the DMV, and the DMV will, in most cases, transfer that title over. There's been a few cases where they do require you to go through probate, but there's really no way to get a vehicle retitled without adding a person to a vehicle, and I really don't recommend doing that. In fact, Matthew can respond to that, because if you add another person to that vehicle, you open yourself up, and that person
more liability if they cause crash or anything like that. I didn't know the DMV will just transfer the title even without a probate order.
They'll do it without a probate order in most cases if they have a death certificate and a will, and the will says where everything's supposed to go. Where they get a little iffy is when they don't have any instructions, unless you're the spouse and it says that, Frank died and I'm survived by Susie, and Susie goes down with the death certificate, they'll transfer it in that case.
Lisa, was that helpful for you?
It was very helpful. Thank you so much. That was one thing that was hanging over my head. Thank you so much. I appreciate the show.
Thank you for calling.
Thank you very much. Thank you for calling. And it looks like Lisa has taken some of the steps to do that, which is wonderful. But it's really a whole process. It's not just piecemeal. I mean, really to really preserve your legacy and to preserve your assets, you got to look at it as the full animal, right?
Well, and she's taken a lot of really good steps. There are some caveats that you have to pay attention to when you use beneficiary designations. If you have stepchildren, and you're not specifically listing those stepchildren, for example, I shouldn't say stepchildren, be more along the lines of step grandchildren. So there's a designation that you can mark when you do a beneficiary form on an IRA. It's called per stirpes, and that per stirpes will follow bloodlines.
Well, I remember that from law school, but that's all I remember is the name.
It's a fancy Latin term that simply means we're going to follow bloodlines. So if you were to have an IRA and you were to list everything goes to my child, but then you check the per stirpes box and you and your child pass away at the same time, then your grandchildren should be able to get the assets if you had grandchildren. That doesn't apply if you have step grandchildren. So a lot of people have step grandchildren that they consider the same as blood grandchildren. And if you want those to inherit, then you specifically have to list those names. And the best way to do that is to have a trust so you can account for those different things.
Wow. There's so much that you need to think about, and so much that you don't even think about that you wouldn't even think to ask. So that's why they need to talk to somebody like you, Adam, to guide them through the maze. We always say, as we represent people after auto accidents, that we guide them through the maze of the civil lawsuit and insurance claim and such like that. But your maze is just as crazy as our maze.
It can be very crazy, yes.
And so you need to have somebody who guides you through that maze. Adam, when you're not here on FLALAW on the radio, how can they get in touch with you?
You can reach me at the office, 727-250-0432, or you can reach me by email at adam@preservationlawfirm.com. My website is preservationlawfirm.com.
Perfect. And I highly recommend, if you have questions, that you reach out to Adam, because as you can hear, there are so many caveats that could really have an impact on you. Not really on you, but on your survivors, because you've passed away. And if you're taking steps, all the steps you can to minimize the impact of your death has on your survivors, I think it's so important to talk to you about that.
Well, one thing I'd like to mention too, again, when you list beneficiaries, if you're listing individuals, I just had a lady that passed away and she had listed her 4 children directly on the Ladybird deed to inherit. Prior to her death, her son had passed away. So her son's share technically transferred to his wife and his kids because they had kids from separate marriages. And then his wife had passed away, and then one of her children passed away. So from one Ladybird deed, we ended up having to open up 3 probates for 3 of the beneficiaries that came from the Ladybird deed. So again, a trust accounts for that, and we wouldn't have the probates. We could count for it inside the trust. You do a Ladybird deed to the trust, the house goes to the trust, and the trust can distribute the assets as necessary without any probates at all.
And I think that is a good reminder for our listeners that just because you do it once, you're not one and done. No, how important is it to refresh your estate planning?
I recommend my clients come in and sit down every 3 to 5 years. We need to go over things, either that or when a life event happens. So somebody passes away or something else happens in your life, sit back down, go over the documents you have, and review those documents with your attorney.
I think that is important. And life event, it could be a death, like you were saying, like a death of a child.
Death, a disability, some sort of illness.
Right. Marriage or divorce. And such
Marriage
like
or divorce and other ones.
Yeah. Well, I think that's very helpful. I think we're going to take our first commercial break here. When we come back, we're going to talk more about avoiding probate, common pitfalls and such. So give us a call during the break if you have questions at 727-441-3000. I'll see you right on the other side of the break.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
We are back. I am Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the oldest personal injury law firm in Tampa Bay. We have been helping people after car accidents, work accidents, Social Security disability claims since 1955. This year we celebrate our 70th birthday. So happy birthday to us. We are here as as a thanks to you all for having your trust in us. So we feel it's important to give back to the community. And that's why we host this show, FLALAW, every Tuesday from 5 until 6 here on the Talk Tan Radio. But it's not just us. We also bring very wise people in to help educate you and answer your question as well in other areas of law. And that's why Adam is here. Thank you, Adam, again.
I appreciate the opportunity to be here.
The new listeners, Adam Rauman is a probate attorney here in Largo, and he is here today to answer any questions you have regarding wills, trust, estate planning, and other areas of law that plays into there. It's amazing how we can say we do this, and then it always spans out to real estate law or other types of law that we have to do.
Everything seems to fit in together, doesn't it?
It's like a spider web. Yeah, no. But we were talking before the break. We were talking about a will, and we were talking about a trust, and the benefits of both, or the specifics of both. But many people die without a will and without a trust. Is that right?
That's correct.
And what happens?
So that's called intestate. It's just a fancy way to say you pass without a will. And the Florida statutes tell you where your assets are going to go. So if somebody passes away without a will, the statutes say that the first beneficiary is going to be your spouse. If you don't have a spouse, it goes to kids. If you don't have kids, it goes to grandkids or great-grandkids. If you don't have any of those, now we're going up to your parents. If your parents are deceased, we're out to siblings and nieces and nephews. If we can't find any of those, then we're going all the way up to grandparents.
Wow.
So it gets really complicated.
Spider web, again, another spider web.
And
keeps
building
going
out. And that gets expensive to try to find all those people if we don't have any of the immediate family around.
Sure. And the personal representative would have to be appointed for that as well, because there's no will saying who's in charge of that estate, so to speak. We
can get a personal representative or a curator. Curator can come in to help find those people if we don't know who any of those people are. If somebody passes away and we just know there's a house and that's all we know of, we can turn around and have a curator so we can try to find those beneficiaries and then have a personal representative appointed and go from there.
And I know the general public sometimes thinks that, you die without a will or an estate or a will or a trust. It just goes, all your assets go to the state, but that's the last resort after you've gone through that whole spider web. Is that right?
Yeah. Assets end up going there if we can't find anybody else out there to give any assets to. And then they sit with the state for a number of years until somebody can come forward and prove why those assets belong to them. And then they would get them. Otherwise, the state does end up with it. But the state tells you where those assets are going to go. So if you want to decide where your assets are going, then you need to have at a minimum a will so you can decide where your assets are going, or the trust so you can help avoid probate. And I keep telling people that how to avoid probate. I make a lot of money in probate, so I really like it.
That's true. But what common mistakes do people make, on the Google Esquire and such like that? What common mistakes do people make when they're drafting their own will or using a template that they pulled up off of Google or any other thing?
A lot of times you'll see documents that aren't properly executed. So in order to have a valid will in the state of Florida, it has to be executed by the testator, the person who's making the will at the end. You tell me what the end is.
Okay.
And then it's supposed to be witnessed by two witnesses. It doesn't have to be notarized, but you do have to have those two witnesses. And some of the problems come in when you can't tell who those names of those witnesses are. We run into problems. I've had wills where the person is signed at the end and they've had a notary done. That's not a valid will. We end up back in intestate because that doesn't work.
Because they don't have the two witnesses?
Because they don't have the two witnesses, okay. So it's not a valid document.
Yeah. Okay. And I know every state has different specifications as what's required for a valid will. What happens if you have a will, you did your will up in New York, then you moved down here? I don't know what the will specifications in New York are, but let's say it's one witness.
Sure. So long as the will is properly executed in the state where you resided when you did the will, Florida will recognize it. And that counts for other countries too. So if you have a will that you did when you lived over in France, so long as we can figure out what those requirements were, we can probate that will here in the U.S. And so probate isn't just for Florida residents only. It's for anybody who owns assets in Florida. So if you own real property, but you live in another state and you don't properly take care of those assets, you're going to have a Florida probate.
You set me up just perfectly for the next question I had. What if that person who came from New York and moved down to Florida has property up in New York?
So again, every state that you own real property, you're going to have to do a probate. Now, if you just have bank accounts or brokerage accounts, those are personal assets. So where you live, they even if the bank is only in New York, it's technically a Florida asset to transfer.
Okay.
But it's the real property that causes people to open multiple probates in multiple states.
And a way to avoid all those multiple probates in all those multiple states is through a trust,
It's
right?
through a trust.
Or, I mean, could you also have designations for the joint tenancy, or
you could jointly own those properties with other people? Yes.
Okay.
You could have a corporation and you could put a beneficiary designation on the corporation. Some states, not all of them, have ladybird deeds. I can't remember off the top of my head which states do and which states don't, so I always have to go back and look. But if you can do a ladybird deed, that's just a beneficiary designation. That's a great way to do it.
And does a ladybird deed have to be, can it be anybody, or does it have to be a relative?
No, you can do a ladybird deed to anybody.
Okay.
So if your next door neighbor wants your house and you want to make sure your neighbor gets it, we can do a ladybird deed to your neighbor if that's what you like.
Okay. Now, I didn't ask you if you know this question or not, or the answer. Why is it called ladybird deed?
So it's named after Lady Bird Johnson. The official name for it is technically an enhanced life estate deed, but that sometimes confuses
Ladybird sounds
people.
cooler.
Yeah, it does. So there's two types of life estates. There's the regular life estate, where if I made you the beneficiary and I did a life estate, if I wanted to sell the property, I would need you to join me to sell.
Okay.
The ladybird deed or enhanced life estate, I maintain 100% ownership in it. I control it. If I want to sell it, I do it. You don't get an interest until I pass away. So it's just easier to refer to a ladybird deed, so we're not confusing anybody on what type of deed they need to do.
Oh, that makes sense. Now we're talking about houses. Lisa asked about her car and other assets. What about pets? I think people are very attached to their pets.
I understand.
And I know you have. You were going to bring your puppy here.
I was going to bring my dog comes to my office with me just about every day, and I've got 2 cats at the house, so I completely understand wanting to take care of your pets.
Yeah. How can somebody preserve their relationship with their pet, or protect their pet from being taken care of after they pass away?
So unfortunately, we can't leave money to a pet, but what I can do is I can name a person and say, if Steve takes my pets, then I'm going to give Steve X amount of dollars to care for my pets as an incentive. Now, if Steve wants to use that money to care for the pets, great. If Steve wants to use the money and go on vacation, that's up to Steve. But at least you compensated Steve for taking your pets, because pets can be expensive. So that's the easiest way to do it, is to designate somebody to get your pets and designate some amount of money to go to them.
Would that be through the will or the trust, or either?
Either one of the two, we can do it. Those personal type items, if they're just listed in the trust and they really, or the will, and they don't really have much of a value, then we don't have to worry about probate. With the pets, because you have a dollar amount you're designating through there, we would. But if you were to say, for example, my wedding or my photos in my house, I want to go to Susie, I don't necessarily have to open up probate to give Susie your photos.
Okay. My Cubs collection, my kids are fighting about who doesn't get all my Cubs memorabilia.
Who wouldn't want that? I'm a White Sox fan, so it's not me. So.
Neither one of them really want it. But so whichever one's the meanest to me near my end, I think is what I'll leave it to. So
there you go.
But I think that's what we have heard and what we have seen is, I knew a couple that wrote a little Post-it notes on certain things around the house that they wanted to give to this grandchild, this child, and such like that. So is that something that's valid? Can they do that for personal property?
The easiest thing to do is to have a will, and then you get what's called a separate writing, which you can do at any time after the will is done. And the separate writing simply says, this item goes to this person, and then as long as it's dated and signed, we can use it. If it's not dated and signed, it's not valid.
Okay.
If your beneficiaries want to honor it, that's up to them. But if Steve really wants that ring that you were going to give to James, then it's not going to work because it wasn't dated and signed.
Okay. And is that only personal property, or can that be any type of property for the separate writing?
It's best used for personal property, rings, jewelry, photos, furniture, collectibles, those types of things.
Okay. All right. That sounds good. Now, I did want to talk about, because we're talking about family. I come from a family that has 10 brothers. I have 10 brothers and sisters, so we have a huge family. And we never fight.
Never.
But I understand that sometimes people think probate is just a fancy word for family drama with attorney's fees.
Well, it can be.
Yeah. So in your experience, what role does the family dynamics have when it comes to probate, estate planning, estate preservation, and such like that?
Well, unfortunately, anytime you're going to have any sort of arguing between family members, even if you just have a trust and you properly set everything up, you could end up with that trust and the will ended up going through either trust litigation or probate litigation. And anytime there's some sort of dispute, unfortunately, we have to go to the court to get the court to give an answer to it.
What type of issues would that be like?
Well, I had one probate we did. Mom was very specific in there. She gave the house equally to her 4 kids, and the house was the only asset she had. The kids were divided, 2 on one side and 2 on the other. And the 2 on one side, we'll call them the bad kids, thought they were causing the good kids just personal expenses. So they kept arguing about everything. And even though the will was pretty clear, they rang up $30,000 in attorney's fees in order to transfer a $130,000 house.
Wow.
And they didn't realize they were paying 50% of those attorney's fees.
Wow. Yeah.
We kept telling them they were, the judge kept telling them they were, but it just didn't click in until the very end.
Yeah, they're diluting the asset.
Exactly.
Yeah.
So you once had a $130,000 estate where you were going to divide it 4 ways. They ended up with a $100,000 estate. They divided 4 ways.
Yeah. So they lost $15,000 if I did the math quickly.
So
each.
It can be expensive if you have disputes. I've got a probate case right now where it's pretty clear cut and dry, but one sibling just doesn't trust the other one, so they feel it's necessary to have an attorney. And I would never tell anyone not to have an attorney, but they just have to realize that when you do that and you get other attorneys involved, and those attorneys' fees are going up, because we talked about the percentages, but those are on normal probates. Once you end up with what's called extraordinary, anything out of the ordinary, you could end up with attorney's fees being charged on a per hour rate. And you're looking at your attorney and then the attorney that's working for the estate.
And so the beneficiary, let's say the beneficiary had a dispute, they can hire an attorney to fight what they feel they're entitled to under the will or under the trust?
Absolutely.
Okay.
So even Florida doesn't have what's called a no contest rule. Some states have that. You can write it into your will that if anyone wants to contest my will, that they're not going to inherit. In Florida, that does not work. Anybody who wants to contest a will or a trust has the ability to do that. That's their right. And any beneficiary that has any issues with what something says in the will or how it's being handled can hire an attorney and end up going into litigation to make sure they get what they're entitled to.
And that person's, the beneficiary's attorney's fees are paid still out of the estate?
They can be.
Okay.
It's really going to be up to the beneficiary to pay those fees. And then what happens a lot of times is everybody will agree at the end to take all the attorney's fees off the top.
Wow. And so, again, you're not preserving the asset.
You're not preserving the assets.
They're going totally against the name of your law firm.
We tried to make it easy, and you ended up in a dispute. So.
Oh, goodness. And I guess through your experience, I guess you have seen a lot of families, get torn apart because of the estate.
Well, the famous last words are, my kids love each other, and they're never going to fight.
Right.
Of course they're not.
Yeah. And I guess that raises a question, when dad or mom come in to your office to begin the preservation of their assets, sometimes their kids take them. What do you do to prevent, influence from one child or the other child? So
in my office, the way I handle that, I don't care if your kids come in with you, if they want to talk in general, what is a trust? What is a will? What's a power of attorney, healthcare surrogate? How do these documents work? I'll talk to everybody in a group setting about that. But once it gets down to what are we doing specifically for mom and dad, then I have the kids leave. The only people that I talk to are the client. And the client is whoever is making the will or the trust.
Okay.
I draft the documents. The client gets the documents. And then when the client comes in to sign the documents, I'm only meeting with the client to go over those documents to make sure those documents are what the client wants to say. If I feel that the client is being influenced by somebody, I won't do the signing. And every single one of those is done the same. I don't care if you're an only child and you're bringing dad in and you want to make sure dad gets his stuff done. That's fine. Dad and I are going to sit there and talk anyway, just in case he wants to give all of his assets to somebody who's not you.
Yeah. And they can do that. I mean, I hear that some kids are written out of the will, so to speak, or
disinherited. It happens quite often, actually.
Does it really?
It really. In fact, I talked to a person today. They're disinheriting one of their kids.
Oh, wow. Wow. And sometimes it's not out of spite. It could be because one child is financially stable and the other one's not. Is that fair?
That's the case sometimes. Sometimes it's because, Susie took care of me the whole time and, David never came down to visit me at all. So I'm giving all the money to Susie. I get that also.
And they have the right to do that.
And then I've had other ones who just give all the money to charity. They don't want to give any money to their kids at all.
Really?
So 100% goes to charity.
Wow. That's pretty interesting. That is pretty interesting. And have you had situations where you thought a family member was being a little overly influencing the person writing the will?
I have, and that's when I cut off the relationship. I won't do any work for them at all. Again, I don't mind if you bring your parents. I don't mind who drives you over there. I just don't want those people around. And if I feel that you're being influenced and giving things a certain way, just because that person that's sitting out in the other room is making you do it, I won't do the will. That's one of the reasons why when we do a signing, we have to do them in person. We don't do what are called video signings very often, just because I can't tell who's in the room with you and whether or not you're being influenced to sign a document you don't want to sign. So,
well, that's so important at this age of everything's electrically signed now. It's great that type of thing is done in person.
So all the wills, trusts, power of attorney, healthcare surrogate, all those estate planning documents always have a wet signature, and I prefer to do those in office.
That's perfect. Now, we touched a little bit about on a few other documents that are part of the estate planning that's outside the will and outside the trust, and that's the power of attorney, a living will, and such like that. Can you tell our listeners a little bit about what those are and why they're important?
So a power of attorney allows somebody to act legally and financially for you. And I always pause here. It's valid from the minute you sign it, but in order for that person to use it, you physically have to give them a fax copy, photocopy, electronic copy, or an original. So I have my clients sign it, but I tell them never to hand it over. I always wait for something to happen and then have that person call me and say, hey, dad was in an accident. We need a power of attorney. We try to verify the situation with the doctors and then decide whether or not we should release the document. No. Now, if you get home and you decide to hand it over to your kid, just realize that they can go to the bank and they can access your bank account starting that day.
Yeah.
Yep. Then you have a healthcare surrogate. Somebody is allowed to make healthcare decisions for you. That one comes and goes in power. Your doctor says you're not capable of making decisions because maybe we have you under anesthesia or on medication. Then where you're with your healthcare surrogate, as soon as you're able to make those, you're back to making those decisions yourself. And then there's a living will. A living will only applies in 3 circumstances: a terminal condition, an end stage condition, or a persistent vegetative state. Terminal is disease-based. End stage, your organs are shutting down. In a persistent vegetative state, Terry Schiavo, your brain dead, but your brain stem keeps organs functioning. By having that document, you have said in writing, if I have any one of these conditions, I do not want to be kept alive artificially. I want to pass away naturally.
And that eases the burden of the family that's suffering with your condition.
Because you've given them the instructions. This is what I want you to do if that's me.
So all of those documents are as important as the will or the trust.
I refer to the power of attorney, the healthcare surrogate, and the living will as living documents because they're only valid while you're alive. So they do protect you and your assets and your family while you're alive. The will and the trust, the will comes in after you pass away. The trust is there while you're alive and after you pass away.
And unfortunately, many people think, well, I have the power of attorney. And so dad named me as power of attorney, but now dad's passed away. so I can use that power of attorney. That power of attorney is no longer valid when the person dies. Is that correct?
Exactly. It's invalid as soon as somebody passes away. So the power goes when the individual dies.
What about mental capacity? What if they're not dead, but
so the power of attorney is not invalidated by incapacity. So that's why you want to have it. The durable power of attorney in the state of Florida works despite mental capacity.
Okay. That's why it's written. So if the person's alive but can't make decisions.
Well, we used to have, back before 2011, we used to have what was called a springing power of attorney that wouldn't come into play until you were incapacitated. The problem was getting two doctors to sign off saying, well, he's not really with it enough. We need to release the power of attorney. So Florida got rid of those, and we now only have a durable.
And that's why it's so important that, like, what your practice is, that you hold on to it and you encourage your clients not to pass it out to the
not to hand it out.
Because they could the next day go to the bank account and cash out all the banks if they wanted to. It's
the one document that if somebody's going to do something they're not supposed to do, that's the document they're going to use to get it done.
Yeah, that's unfortunate, but we see it happen too often.
All too often.
Yes. Listeners, we have, probably about 8 more minutes of this show. So if you have questions, you still have time to give us a call at 727-441-3000, or jump on our Facebook live at Perenich, Caulfield, Avril Noyes. Type in your questions there, and we'll be able to tackle those if you don't want your question or your voice on the air. Or you can even jump to our YouTube channel and type in your question there. Again, it's Perenich, Caulfield, Avril Noyes Injury Lawyers. Perenich is spelled Perenich. This is Matthew Noyes with the law firm of Perenich, Caulfield, Avril Noyes. We are the oldest personal injury law firm in Tampa Bay since 1955. And I have Adam Rauman here as well. He has been an attorney for 10 years, 15 years? No,
actually 15 years.
Yeah, 15 years as an attorney and 15 years as a financial advisor.
Yeah, now you're telling everybody how old I am.
Well, I can do that because I've been doing it for 30 some odd years myself. So, so Adam is well versed in not only the probate matters, but the impact financial advising has on probate. So, Adam, again, thank you very much for coming to share your wisdom in those areas.
I appreciate the opportunity.
I also want, for our new listeners, I want them to know how they can get in touch with you again one more time.
So you can reach me at my office, 727-250-0432. You can reach me by email at adam@preservationlawfirm.com, or you can go to my website, which is preservationlawfirm.com.
And if you go to his law firm, you'll see his dog. What's your dog's name?
Bruno.
Bruno. Okay.
Most days Bruno is there. Yes.
All right. My law partner, Lori Robinson, has 2 special dogs herself. And I think she would love to have the dogs come over to the office once in a while. This is dating myself. Our firm used to have FLALAW on television. And so it was a live TV show. And we would have the SPCA, and Bob Carroll and Lou Quall, who used to be an attorney here in Clearwater, they would bring their dogs onto the set. And I don't know if it was Lou's dog or if it was Bob's dog that would be biting the tassels off of one of the attorney's shoes. And they're trying to do the show, ignoring that the dog is biting their tassels. So on the radio, I guess they wouldn't see that, but dogs are very, very special to many people.
And I always ask before Bruno comes in and sees anybody, whether or not they like dogs and are okay with meeting him. Otherwise, he stays back in my office and behind a closed door.
Oh, that's good. And, and that's why we talked about just a few minutes ago, the importance of preserving the relationship with the dog. So, too many times, I guess, people pass away that may have pets, and if there's no directive about what to do with the pets and that none of the family wants it, I guess they go to the pound. Or
unfortunately, they end up in the shelter. And some of those pets, like turtles and birds, can live for much, much longer than we can live. So.
Yeah. So that's why it's important. That's part of preserving the asset. Your pet could be, certainly it's considered an asset to you. And so it's important to take steps to protect them should you should you die, but when you die. Right now,
unfortunately, we're all going to pass away someday. Yes.
Eventually, everyone's going to do that. See, in your line of work, eventually people are going to need you. We hope in our personal injury field that people don't need us because we only meet very good people after bad things happen to them.
You're either going to come see me to do that pre-planning, or your family's going to come see me to do the probate afterwards. So and one way or another.
And can you tell our listeners a little bit why it's better for the person to do it as opposed to the family?
So when you're doing it, you get to decide where things go and how things are done, and you can avoid those probate expenses because they already have to go through your loss and then having to deal with an attorney and the time and the courts. I mean, the reason probate takes as long as it does is because there are set time limits that we have to do certain things. For example, creditors have 90 days after we get a probate open to file a claim. So for 90 days, we sit there, you're running around finding assets or distributing assets, but we're not doing anything on the probate side. It's waiting for that time period to pass.
Right. So I mean, you can have the house sitting there. It can't be sold until all that process goes through.
And that's just more expenses out of pocket to pay for things if you have an estate that doesn't have a whole lot of cash to use. So
right.
the estate is supposed to be paying those expenses, but if your only asset is that house, then you're coming out of pocket to pay for that until you're able to sell the house and get reimbursed.
And I think the personal representative, one of their duties also is to try to find creditors, right?
They have to do their due diligence to find as many creditors, known creditors as they can. And just to make sure we're covering our bases, we also look for unknown creditors. So we have to publish a notice to creditors. So just the probate cost can run anywhere between $500 and $1,000 on that side.
Okay. Yeah, and the purpose to do that is so that creditors don't come knocking on the door after the probate's all done. Is that right?
So if we didn't look for creditors and we had a known creditor, or what we call an easily ascertainable creditor, you knew your mom was going to see Dr. Smith and you knew Dr. Smith was going to have a bill and you decided you just were going to give yourself all of the assets, Dr. Smith can technically sue you in that case and make you responsible for paying for it. So if you do the right thing, you open up probate and you properly provide notices, then we can cut off Dr. Smith's ability to file a claim by providing him with a shorter period for notice.
Okay, sounds good. And is it a 2-year period of time to bring a claim, or is it shorter than that?
It's 2 years until you open up probate. So if we open up probate, we can take the 2-year window down to 90 days. So every estate, 2 years after somebody passes away, a claim can be filed in their estate.
Perfect. We're about to wrap up this hour, but if you could tell our listeners, in a sentence or two, what's the biggest piece of advice that you would give your own family about probate and estate planning?
Just make sure you put an estate plan in place. You always hear about planning makes perfection. Well, planning can save the family a lot of time and headache too.
Perfect. Adam, thank you very much. Can you give your telephone number one more time before we...
727-250-0432.
And listeners, we thank you for listening to FLALAW on the radio. I will be back next week with another show. But in the meantime, drive safely and watch out for those who don't. Take care.